Ladies and gentlemen, welcome to this event. My name's John Bowers. I'm a country member of Chambers because I'm based in Oxford, but I think I'm the only one old enough to remember when Labour was last in power and put forward some similar measures. I also remember when Keir Starmer was a young barrister acting in the miners' strikes, actually. So we're in for a real cornucopia of discussion and what we call thought leadership. So these are not going to be lectures. They're intended to insert some thought into your heads. I'll introduce the speakers as we come to them. As you, I'm sure, know, the Employment Rights Bill is 150 pages, has 100 pages of explanatory notes, and we've promised a lot of statutory instruments just to round it all off. So I'm sure that there's plenty to keep us occupied. We'll only be 5 hours tonight, and then there'll be drinks. We will be making a recording, and a note will be taken by one of the members of Chambers, Tim Goodwin. So you don't need to take copious notes unless you wish to. So this is a bill that the Chancellor of the Exchequer, at least when I came here this afternoon, Rachel Reeves said that economic prosperity and social justice go hand in hand. And our first speaker can very much convey that message. He's Tim Sharp, and he's the Employment Rights Officer of the TUC, and he leads the TUC's activity on employment rights policy and legislation. So I hope you'll give him a warm round of applause, at least before he speaks. And so let's hear it for Tim Sharp. Thank you.
Thank you very much. I was hoping just to use my comments to talk a bit about the backdrop to the Employment Rights Bill and some of the policy challenges that we think the bill starts to address. When Keir Starmer spoke to the TUC Congress just after his election win, he promised the biggest upgrade of workers' rights in a generation. And we're very much the opinion that it's an upgrade that's badly needed. The last decade and a half has been grim for workers, particularly those at the sharp end of the labour market. More and more people stuck in insecure work, rise of 0 hours contracts, seasonal work, great growth in low-paid unemployment. And so we think there's about 4 million people in these roles, up by more than 1 million since 2011. and the rate of insecure work has been growing about 3 times faster than rates of secure employment. And there are human beings on the ends of those numbers. So the people unsure if they're going to pay their bills because they don't know if the shift they expected tomorrow is going to materialise, a parent unable to plan proper care for their child because they're waiting for the midnight call about tomorrow's schedule. And if you've seen some recent BBC coverage of McDonald's, what's going on at McDonald's, it's the young woman unable to challenge foul behaviour in the workplace because she doesn't want to lose future work. Under the last government, ministers lacked interest in this agenda, even on some of the modest and frankly uninspiring reforms that were proposed. If anyone does remember the unlamented Taylor review, these were largely ignored, and we counted 20 times ministers had promised an employment bill, but nothing was tabled. And the rise of this growth in insecure and low-paid work has implications beyond those individuals affected. The Marmot review of 15 years ago was clear that insecure work was bad for health. This is a knock-on impact that affects individuals involved, but it means that we're seeing large numbers of people dropping out of the workforce due to ill health, and it's bad for public finances. More spending on welfare to top up inadequate wages. So while insecurity has been rising, workers seeking to organise collectively to improve or defend terms and conditions have been hindered up to now by government policy. We did legislation like the Trade Union Act 2016, extra strike hurdles, picketing restrictions, beefed up powers for the certification officer. And then, frankly, slightly unhinged legislation in the form of the Strikes Act 2024 with completely unworkable minimum service rules and a sort of strange sort of culture war attempt to set employer against workers and workers against unions. And I think that the result of this sort of increased precarity and a clampdown on collective action hasn't been to create a less sunny Silicon Valley. The economy is basically flatlined since 2010. We've become a country characterised by lacklustre wage growth, but also great income inequality. And wages across the country are nowhere near they would have been if they'd grown at pre-2010 rates. So the TUC is a strong supporter of the government's Employment Rights Bill and its wider package that's sometimes billed as a New Deal and was later rebranded as a Labour's plan to make work pay. We think it signals a decisive move away from the failed policies that have been trying for the last 14 years or so, particularly in its vision of what economic growth requires. John had already quoted Rachel Reeves' point that economic prosperity and social justice go hand in hand, and we think this reflects the way that mainstream economic thinking has been evolving. That link between a simple trade-off between workers' rights and economic growth has been debunked. The OECD, whose 1994 job strategy was the great driver of liberalisation and deregulation in labour markets across the OECD, has changed tack as the empirical evidence has failed to materialise. Their more recent interventions say that it's possible to design policies that simultaneously raise job quantity, job quality, and inclusiveness. And that their research has shown that collective bargaining between workers and employers is good for both productivity and employment. Close to home, recent study by Deakin and Pukarani using a database of employment protection legislation across the world dating back to the 70s showed that labour protections on average increased employment and reduced unemployment. And the same authors have found as well that on almost every measure of employment protection, the UK lags behind the average for other OECD countries. So there is a lot of catching up to do, and the Employment Rights Bill, it starts that journey. It encourages a stronger voice for workers, acknowledging that fundamental imbalance of power between workers and employers. So as a result, that absurd 2024 Strikes Act that was demanded by no one and used by precisely nobody, that'll be going. Also going is virtually all of the Trade Union Act 2016. Itself designed to tilt that balance of power towards employers by constraining the ability of workers to take strike action. And in their place, there will be measures that will boost help unions boost their presence in the workplace, and by doing so should help workers achieve and fight for decent pay and conditions. I think significant for us is that in particularly new parts of the economy, large parts of the economy, there's very little tradition of trade union presence. For a long time, union organisers have had stand with sort of soggy leaflets outside a warehouse in the middle of nowhere, desperately trying to recruit new members. This bill gives them rights to access workplaces to talk to potential members, and we hope that digital access rights will also find their way into the bill in the flurry of amendments that will no doubt be part of report stage 2. So that will capture the large number of workers who aren't typically in a physical workplace. And important improvements to the recognition rules will likely lead to the lowering of the trigger for statutory recognition, and consultations on tightening up of unfair practices. should mean that some of the particularly hostile behaviour we've seen, I think, Amazon in Coventry most recently, flooding a bargaining unit with new hires, that will hopefully become a thing of the past. And there's also an important new step in bringing forward sexual collective bargaining in a form, beginning with a fair pay agreement for social care, a floor on terms and conditions in a sector notorious for low pay and insecure forms of work will in future be negotiated between employers and workers. And there's also significant measures about where workers should gain a stronger voice, where job cuts are planned, such as closure of the other Woolworths loophole and plans to increase protective awards. On top of that, the individual rights, there's useful measures that would significantly, we think, curtail the use of 0 hours contracts. I mean, take the right to a guaranteed hours contract after 12 weeks. That could transform a labour market where we've worked out that 2/3 of those on 0 hours contracts have been with their employer for more than a year, and 1 in 8 for more than a decade. These sorts of contracts are not being used to cover holidays or plug gaps. They're keeping many workers in a perpetual state of insecurity. And our polling shows that 80% of 0 hours workers want a guaranteed hours contract that this legislation has the potential to deliver. And likewise, the requirement for decent notice of shifts, while still quite undefined, has the potential to end situations where workers don't know, until the middle of the night before they're due to work, whether they've got a shift tomorrow or end up heading back home while en route to their shift. The measures on unfair dismissal. I mean, for too long, in parts of the economy, employers have been able to hire a load of workers knowing they could discard the ones that don't fit in. So removal of the 2-year qualifying period should change this, and will provide a far greater incentive, we think, for employers to hire carefully, to train and develop the workers on their books. Also on the list of individual measures, sick pay available to all workers, no matter their income, and from day one. While there are still important decisions to be made about, in particular, about the rate for low earners, and hopefully in time reforms to the headline rate of SSP, it should make it less likely that workers face hardship if they have to take time off for health reasons. And measures to tackle hire and rehire as well should make it harder for employers to simply cut terms and conditions to boost the bottom line. They'll need to make a proper case that their financial state requires these changes. It's notable to us that despite a flurry of sometimes hysterical press coverage, that it appears that these measures are strongly supported by voters. 2/3 back a ban of fire and rehire, 7 in 10 support an end to 0 hours contracts. And despite some of the responses from employers groups, huge numbers of employers back them too. 2/3 of senior managers in companies say that ordinary workers' rights should be strengthened, and 70% say this will help to retain staff. So, senior managers in companies where they're fed up of being undercut by those who would play fast and loose with the rules are keen for change too. So, it's not to say that we're of the view that this bill is once and done. There are large parts of the bill that offer ministers powers, and unions know there are arguments that we made over months, years about what they do with these powers. And there are important questions to be resolved as well in future primary legislation. Employment status, I think particularly that boundary between the self-employed and workers, will become increasingly important, especially after this legislation delivers upgrades to workers, to additional rights on workers. So we think we've got what this legislation delivers is a sort of strong sense of it delivers a strong sense of the direction that the legislation is pushing. It's a set of reforms that boost collective rights, that will better enable workers, if they've got union representation, to access their individual rights, and individual rights putting a floor above which unions can negotiate better conditions. So we think we've got, it's first steps on delivering a labour market where workers have more stability, where their employer has an incentive to train and develop them, where there's grown-up industrial relations, including a stronger collective voice for workers at a workplace and sectoral level. So we think the Employment Rights Bill, while there's a lot still to work out, is a really significant step in the right direction in dealing with a lot of the problems that we've seen build up in the labour market, particularly over the last decade or so.
Well, thank you very much. I should say that we're going to take questions and comments at the end, but can I just clarify one thing, Tim? You see this as the first of several employment rights bills, do you? I mean, this is from the TUC point of view.
Point of view. Well, we'll have many employment rights bills. I think the government's pledge. If we take the Labour's plan to make work pay, they've delivered a lot of that. They've put the basis in for delivering a lot of that in this bill, but they've made pledges around parental rights, for example, which almost certainly have to require primary legislation, and employment status is undoubtedly unfinished business. Now, whether they was not even started business, whether that's dealt with in one big let's have an inquiry and deal with every issue to do with employment status in one big swoop, or will they go, well, the big challenge, and we would encourage them in this, the big challenge is this border between the self-employment and worker status, and deal with that quicker. I don't know, but there's still if they're going to meet the terms of make work pay, and I think trade unions will be encouraging them to do so. There's going to have to be more than one bill. So
I think we can take it there'll be an employment rights bill every year. Thank you very much, Tim, for a very detailed account of the bill. So we're now going to hear from Tarun Tawakley, who's a partner at Lewis Silkin, who is in the lawyers' hot 100. I never made even the cold or middling 100, I should say, but he'll probably explain how that happened. But you're going to present the case for the other side, for the employers.
I've been asked to speak on behalf of business, which is no small task. As I walked over the bridge from my office this afternoon, I was reflecting on the literary technique of pathetic fallacy. I couldn't help but feel like the gloomy storm clouds we all see and were battered by reflects the business mood right now. Why? As I see it, there are 4 key factors playing into uncertainty for business, and only one of them is relevant to the ERB. But they all holistically create a really difficult environment for employers to operate in. First, and most significantly, unless you've been living under a rock for a while, you will know that we've had the hike to employers' national insurance announced in the autumn budget. This is projected to raise some 25 billion by 2029 to 2030, which is fantastic for public finances, but the burden is very much being placed on business, at least initially. Now, I don't know about you, but I get the feeling, certainly from the last few years, most government announcements are sort of trailed in the media in advance or announced on Twitter or whatever it's called now before they go into the Parliament. But this one did seem to really take business by surprise in terms of the hike to national insurance. And I must admit that, like everyone else, I'm guilty of doom scrolling on lots of these social media apps, and I've seen lots of reports that suggest that either the NI hike is going to see 2/3 of employers raise prices for consumers, or at the other end of the spectrum, a report saying that it's going to come out of employees' pockets in the form of reduced salary increases to the tune of £600 each per year. Quite how anyone is able to forecast with that level of certainty, I won't comment on, but you can see the perception that is being given out. And I would sympathise with Tim describing some of these comments as hysterical, but you can see the sort of perception and mood music from business on that front. Secondly, then, you've got the second direct cost to business that comes in this year in the increase to national minimum wage rates, in particular the sharp increase in the 18 to 20 rate. Now, again, employers do try and budget these things in, but ultimately, with these new rates, if you take an employee that's working 37.5 hours a week, that puts minimum wage at just under £24,000. Now, again, I'm not going to talk about the cost of living in London or anything else, but what that figure does do is it takes employers who would have previously felt very comfortable about not being at risk of NMW issues and finding themselves very close to the cusp potentially, particularly when you start factoring in things like salary sacrifice, extra hours worked, the other things we all know are pain points when looking at NMW issues. Then, if that wasn't bad enough for business, we've got the changes in business rates that are coming in April, where the current reduction rates of 70% is dropping to 40%, and it's being capped at an amount of £110,000. And what that will mean for many businesses is they're going to see their business rates double. All of that is a relatively gloomy business context in which to introduce potentially indirect costs in the form of the Employment Rights Bill. But I don't want you to think it's just indirect. So I did, as many of you will have done, trawl through the government's impact assessments and everything else, and they've given the incredibly precise figure that this is going to cost business something less than 5 billion annually, which is obviously a really easy figure to plan for because less than 5 billion doesn't cover a very large delta. But regardless of what the actual direct financial cost of this is, I think we can be very clear that the way the bill works, and Tim's been very good in holding the TUC message in being positive about the bill, but I think speaking to lots of employment lawyers as I have, and I'm sure you all have since the bill was announced, I think the general perception amongst the employment law community was it's a bit of a fudge, quite a few compromises, and that's been necessary to get this through in the government's self-imposed deadline of 100 days. This may well have looked very, very different if that self-imposed deadline didn't exist, and arguably, if on the one hand, not that Tim would say this, but if on the one hand unions think it doesn't go far enough and employers think it goes too far, you might think it's probably getting the balance right because neither side is happy, which is normally a good sign that you've got the balance of the legislation correct. But I've been tasked not to be neutral. In fact, I've been told specifically to put forward the employer's point of view. Be controversial was my brief. And like all of the barristers on the panel with me, I will deliver against that brief. So here we go. I've talked about the context so far. Let's go into the detail of the bill itself. And I'm not going to steal anyone's thunder by going into too much detail of this, but I'm going to introduce some of the concepts that I think are the most concerning, challenging, potentially interesting for employers, and share some potentially controversial views, if nothing else, to get a discussion going. So, as I say, the response from big business, at least to this, has been clear, and it's been one of concern. The CBI chair says nobody wants this bill, and that the initial period of employments, or whatever they end up being defined in the future, are an adventure playground for employment rights lawyers. Well, if nothing else, I've got something to excite my children about what I do day to day, but that's not going to be much comfort to business. So what are the basics? We talked about the fact there hasn't been much change, and Tim's right. If you look at the period 2010 to 2024, really only been two pieces of employment legislation, and both of them have been very much pro-employer in terms of restricting the rights of trade unions. We've heard about the need for rebalancing power, but does the bill go too far? Here are the 5 areas where I'm most concerned in the hats that I'm being asked to wear today. And the first of those is, of course, day one unfair dismissal rights for employees. Ish. So why do I say ish? Because, of course, we know there's going to be some sort of light touch process for dismissals in the initial period of employment. And if anyone can think of a better acronym than IPE, let me know, because I'm not a cricket fan, but my mind just does go to IPL whenever I think about it. And it's going to end up in a pleading at some point, which I hope to avoid. But that allows employers to dismiss for certain reasons, but not everything they're used to. So we've got performance, misconduct, capability, some other substantial reason, but crucially not redundancy. Again, the exact nature of this is all still up in the air, but the next steps document seems to suggest there's going to have to be some sort of a meeting. What does that mean for employers? What happens if your employee senses that the writing is on the wall and, not that this would ever happen, gets a sick note signing them off work for a significant period of time and you can't get the meeting done in time? Again, not something we've ever seen in practice, but a potential risk, you might say. What happens if, God forbid, you've got an even more serious? What if the employee is in custody? You can't meet with them. Are employers going to be deprived of the protection of the IP if they can't meet the rules of the specific guidance? We all, well, not we all, speaking for myself, some of us will remember the statutory dispute resolution completions, and we're very keen to stay away from that and the hell that that entailed. But exactly what these rules are going to require isn't clear. Again, you've got this interesting problem of the rules not applying to redundancy scenarios. Now, again, I've got some sympathy with the idea that that is a non-fault dismissal for an employee, and therefore why should that fall within this? But again, with these sorts of measures, it's really important to think about the wider potential impact of it, and what is the impact this is going to have on employers thinking about hiring decisions, and whether to make those and go ahead with them if there's a risk that the cost of getting that wrong will be a long and expensive process if they find the economic headwinds turn further against them and they need to make cuts or changes. Again, the length of the IP is up for grabs. I think the current idea is that it's going to be something like 9 months, potentially extendable to 12 if notice is given in the right time. But again, all of that is up in the air. And ultimately, This is all incredibly complex, and arguably it didn't need to be. One can't help but think that was there not a rhetoric around day one employment rights, a very simple unfair dismissal qualifying period of 9 months, 12 months, take your pick, might have been easier, better, more straightforward to implement and result in less tribunal litigation, topic I'll come back to later, if that was the measure that was proposed. Would it be totally out of line with what we've had in the past? No. It's the way unfair dismissal law has worked in the UK since it was first introduced. We've always had a qualifying period. It's varied between 6 months and 2 years with the political winds, as we all know. But it's a concept we're all familiar with, understand, and probably does get the balance right. Again, I've got some sympathy with the idea that an employer doesn't need 2 years to decide whether someone is suitable for a job. But again, I go back to this issue of unintended consequences. I won't take credit for this because it wasn't my idea, but it was Robert Peston on one of his podcasts was talking about the risk that this might actually have a chilling impact on social mobility and whether employers will take a gamble on hiring staff who aren't their typical gone to a particular school, gone to a particular university, whatever else it is, or wider social diversity initiatives, if there's a risk that the cost of getting that wrong in the short term is much higher. At the moment, the status quo does allow for risks to be taken on things like social mobility, arguably for the benefit of all. Finally, then, we don't know what the compensation regime yet looks like for IPE dismissals. All we know is that it might be something less, and there's going to be some consultation about it. So we're going to wait and see what that looks like. Secondly, trade union rights and collective consultation. I'm going to focus more on the latter of those because I think it's the most potentially interesting one for employers. And that is the issue of the establishment point. And we all know the problems that Woolworth created for the TUC movement and for employees generally, but there is a real risk that without further careful thought, large multinational employers could find themselves in a state of perpetual consultation. And I know this is a view that has been shared repeatedly by large employer organisations to DBT and to government. Exactly where that will land is unclear. But again, when you factor that in with the idea of increased protective awards for failure to collectively consult, the risks are very, very high for employers. And could they have done something to soften the blow? Again, being controversial. If they wanted to, we could have had a proposal that clarified Section 1883 and said, OK, we're going to make you consult across multiple sites, but we're going to be really clear you don't look backwards. If you started a consultation exercise, it's not a collective, a couple of people, you've done another exercise in another site that tips you over the threshold. Does that mean you need to collectively consult? It would have been great if we at least had clarity that the answer to that was no. Fire and rehire briefly. Again, I'm not going to add much more to what's in the public debate about the trade-off between contractual certainty and employment protection, but there's a risk that this really prioritised contractual certainty over anything else. And can employers make small changes to change days of work, change hours of work in the retail context that may be necessary without having to show some sort of financial distress? Again, 0 hours workers, low hour workers. Again, we've got this issue about must offer guaranteed hours. Real uncertainty for businesses in terms of how that will work for seasonal workers at the moment. Real uncertainty in terms of just how you have to keep offering these continuous contracts at a regular basis and the administrative burden that will hold. Finally then, and I know it's going to be covered on in much greater detail, so I'll skim over it again, but it's the ability for employers to be held liable for harassment by third parties. Any lawyer that's ever had an argument about reasonable steps versus all reasonable steps will know the potential impact the world all has. And I think it is something that we are all worried about in terms of quite what will happen if an employee can point to a reasonable step that might have been taken that wasn't. Quite what is going to happen in these cases of potential overhearing, discriminatory comments, and how are employers meant to police their clients. These are all difficult issues for employers to grapple with before we even get to the issue of enforcement and the risk of potential dawn raids. Anyone that's helped clients across EMEA or Europe will be familiar with how labour inspectors operate and the administrative burden and hassle that can be put on employers in seeking to address that. So, my final parting thought before I move on then is, could we have done something very, very different? And my challenge to all of you now and to report back to me either over drinks or if you'd rather enjoy the drinks over email or whatever you choose to do so afterwards. And I do this not in my capacity as speaking on behalf of employers, but in my capacity as chair of the Law Society's Employment Law Committee, where I'm looking for a more balanced solution to these issues, is what else could the bill do? I think this is a real once in a lifetime opportunity to shape the future direction of employment law. And are there radical things that none of us have thought about or ever cared to think about that could be implemented as part of this to try and get the balance right. Some of the more outrageous suggestions I'm going to put to you all to get you all thinking is, if there is going to be an IP process, does it need a hearing? Should basic claims be determined on the papers? Might that speed things up, significantly reduce the burden on the public purse, which is already stretched incredibly thin? What else could the tribunal use to actively case manage cases? Again, this is a wild example, but could you have a similar system to the High Court with masters that actually sit down and case manage cases properly, strike out 45-page lists of issues, getting down to the actual relevant issues, preventing bundles that are 600 lever arch files where 30 pages are referred to in trial, preventing cases where individual respondents are in discrimination cases where they once met the claimant for a coffee briefly 12 years ago. Are these things really necessary to get all the way through to trial because we know how difficult they are to strike out? Could actually there be some streamlining of the processes, some other changes that actually reduce the impact of these? Because actually, as much as I've been asked to drum the pro-employer slant, the real issue for business isn't actually complying with the law. It's the cost and the hassle of dealing with the consequences afterwards. It's the cost and the hassle of litigation. It's presidential directions today saying you can't have witnesses in foreign countries giving evidence by video link because it's more proportionate to fly them into the country. These are the things that employers worry about, as we know, when we act for them. And if those sorts of things can be addressed, there may be a better balance to be struck.
Thank you very much indeed. I'm tempted to ask you what the IPL is, but we'll pass over that. I do want to ask you, though, you've put up these sort of great difficulties for business. But is there anything for good employers to fear in this? I can see that bad employers who want to have 0 hours contract might fear this or want to get rid of people inappropriately in the first year or so. But why do good employers have anything to fear from this?
I think it's the risks that arise from this sort of all reasonable steps versus reasonable steps, the unintended consequences of quite who can harass who in the modern world, the unintended consequences of multi-site redundancy exercises. Again, we've all got wonderful clients that are on top of absolutely everything they do, but it's not difficult to imagine circumstances where redundancies happen that aren't tracked on a central tracker. And anyone that's using Excel to try and track them will definitely get it wrong. These are the sorts of things that people need to think about and may have a real impact on business.
Thank you very much indeed. That's really interesting. Indeed. So we now move to the home team. Firstly, David Reade, who, according to the handout, is one of the country's leading silks in commercial litigation and employment law. He's appeared in many leading authorities. He's never made it to the Hot 100, however, and in my view is unlikely to. But will you welcome David Reade?
Thank you very much. I'm hoping for the tepid 20 at some point. Thank you. My brief is to talk about some of the collective issues. You probably appreciated that it's such a broad church to talk about that I'm going to pick up on an overarching theme. And the overarching theme, which I suspect you'll not be surprised about, is that what I see as a consequence of particular aspects of the employment bill that I'm going to focus on is a return to the prospects, no doubt the trades unions' keenness to see these implemented reflects this in trades union membership and in increasing collective bargaining within the workplace. And the threads which I think are driving that, one can identify a number of places. The first Tarun identified, and I'm afraid I recognise that it's 11 years since I appeared in Ethel Austin in the European Court of Justice. I was a child advocate at the time, obviously. And I always remember it vividly because I always say the European Court of Justice is a bit like the Eurovision Song Contest, but without the songs. It would be so much better if it had them. But you'll recollect the chaos before that case, when in the UK we decided that establishment, for the purposes of triggering collective redundancy consultation, embraced the entire workforce of an employer across the company. Well, as Tarun's alluded to, as it stands, the basic implementation of the Act will remove the word establishment, and we'll be back to that. And of course, it's not simply a question of protective award claims. If you remember that far back, you'll remember the Secretary of State being inundated with notifications under the legislation of collective redundancies in order to ensure that you didn't commit a criminal offence in relation to matters. So why do I think that's going to impact? Well, the reason I think it'll impact on trades union membership is that if you're looking at it, what I frequently say to people is the most effective defence against claims for collective redundancy by way of protective award is to have a standing elected body of consultative forum for redundancies. Now, even if you get it wrong, the advantage with a standing collective forum is that they're the only people that have the rights to bring claims in relation to collective redundancies. It's a quirk of the law that other people are disenfranchised. So a bit like works councils, if you keep your body on board with what you're doing or your mistakes, you're not likely to face collective redundancy claims. But my experience, no doubt also of others in the room, the existence of representative forums in a workplace is often been the springboard for successful recognition applications by trades union members, because apathy typically rules. People don't stand for election to those bodies unless they want to advance a particular view or cause. So you put it in place, but you're actually creating the prospect of a good campaigning position for members of the trades union to show we actively are protecting workers' rights by speaking in this forum. So that's the first factor. The second factor are significant changes in trades union recognition. And there are three things going on there. The first is, you'll recollect that the first thing you have to do in a trades union recognition application is show that you've got 10% membership of the bargaining unit. The proposals include the ability for that to be reduced down to 2%. The second thing, that sometimes doesn't seem like much of a barrier, but actually in practice can be, is that you have to show that you're likely to have majority support for trades union recognition. Now, that's often where employers successfully run hearts and minds campaigns, we'll come back to that, about persuading the workforce that existing structures or arrangements don't really require recognition. That will disappear under the Employment Rights Act. The third area, of course, was that there was a trigger that if you got as far as a ballot, you had to show that 40% of those in the bargaining unit were supporting collective bargaining. That will disappear as well, so a simple majority. So the prospect of collective redundancy to the CAC might see a situation where the trades union has only 2% membership in its proposed bargaining unit, so a much bigger bargaining unit could be contemplated. It doesn't have to show likely levels of support, and it only has to show majority support for those taking part in the vote on the ballot. And then we come to the third thing, because hearts and minds. The disadvantage the unions have had, and Tim rightly recognised this, standing outside a well-known warehouse, no doubt, handing out leaflets in the rain, is that if you had an employer whose face was turned to trades union membership, they controlled the pitch when it came to hearts and minds campaigns, because they could exclude effectively, other than outside the workplace, campaigns or approaches trades union activists to encourage membership. That radically changes, so far as the legislation is concerned, by introducing a right to seek access. Now, I know there's one at least chair of the CAC in the room who might have thought, when I talked about making CAC recognition easier, there's my job gone sitting on the CAC. Well, the good news is it's back in a different way, because what a trades union can do, any independent trade union certified as such, to an employer without any level of recognition or existing numbers of memberships, can approach an employer seeking agreement as to access to the workplace for the purposes of recruitment, organising not strikes, but seeking to collectively bargain as well. And the employer is a very mirrored system to the collective recognition process. There's a triggered process of consultation. At the end of the consultation, if the employer reaches agreement to permit that access, there becomes a non-legally enforceable agreement, other than by the CAC, permitting access to the workplace and reasonable facilities for trades unions. If that's not agreed by the worker, by the employer, it goes to the CAC, and the CAC can decide whether or not effectively to impose an agreement. Now, the criteria for that at the moment aren't entirely clear, although looking at the threads, one can see that the way they're shaped will be a bit like recognition that it's going to require a positive view that there is something unreasonably or detrimental about access to the workplace, and the thrust will be to allow it. So that playing field suddenly becomes an even playing field to campaign for a ballot, which you only need to achieve a simple majority on election. So those are three factors which are significantly going to increase membership and collective bargaining. I'll just conclude by just picking up a couple of threads about industrial action. It's absolutely right that the main driver is to revoke the Trades Union Act 2016, which were the reforms about, in particular, ballot notifications, information on ballots, and critically, the 14 days notice of industrial action, which is a very important feature for many employers of the 2006 legislation. That goes back to 7 days. So you have a mandate for industrial action. You only have to give back to the pre-2017 position 7 days notice of that action. So most of the shift is revoking that legislation. Really, there's only one bit of that legislation that survives, and that's the 6-month limitation on ballots. There is a significant shift of greater rights, though, in the legislation, and that's about dismissal. You might remember, if you go back before that act, way back to the initial Labour introductions back in Tony Blair, one of the changes then was to introduce a protected period for industrial action against being dismissed for 12 weeks. And that continued in certain circumstances after the 12 weeks, but typically, as long as your protection was for the 12-week period. The bill appears to remove the period to give a protection against being dismissed for taking part in industrial action without limitation in time. Now, parallel with that, they're reversing Mercer to provide protection short of dismissal. So I assume that these will go together, which means there's a prospect of continuing industrial action for more than 3 months, being reballoted on the 6-month period, and it being protected for employees to either strike and avoid and not be dismissed, or take action short of dismissal, short of strike, but also be protected about action less than dismissal. So it gives a much more powerful weapon for industrial action than just reversing the 2016 changes.
Thank you very much. If you want an advocate in the Central Arbitration Committee, David's your man. So thank you very much indeed. We now move seamlessly to Carol Davis, who's going to speak about Day One rights. She took silk in 2021. She's been recognised for many years as a leading practitioner in both employment litigation and professional disciplines. So tell us about Day One rights and whether the tribunals are going to be flooded with extra claims.
Well, thank you very much. I am going to talk about Day One rights, but I'm also going to dip my toe into the flexible working requests and the exciting world of the proposals in relation to the care sector.
All in 8 minutes.
All in 8 minutes. Looking at Day One rights, of course, the most headline-grabbing one, and the one that's clearly going to excite Tarun's children immensely, given that they involve an adventure playground, which I have to confess had passed me by entirely, is the removal of the 2-year qualifying period to bring a claim for unfair dismissal. The first thing to note is that under the bill, that still unfair dismissal cannot generally be brought until the employee has actually started work, save that there are 2 exceptions. One, if the reason or the principal reason for dismissal is the employee's membership of a reserve force, or that it relates to the political opinions or affiliation of an employee, which means that we can no doubt, John, look forward to many tribunal cases where someone's social media activity results in them being dismissed before they've even stepped foot into the workplace, which is wonderful for us employment lawyers again. To balance the shift towards employee protection, of course, as Tarun mentioned, there is the concept of an initial period of employment, which is introduced. And there are certain things that we know about the IPE. I said IPL, I know absolutely nothing about IPL. But in any event, during the IPE, there still has to be a potentially fair reason for dismissal, and Tarun mentioned those. And it's interesting that the requirement, capability, conduct, inability to work without contravening a statute, or that it's for some other substantial reason relating to the employee and not, on the face of it, the employer, which means, for example, a global decision to make redundancies. It is not with one of the reasons that one can rely upon, albeit that's not yet stated expressly in the Act. We know that the IPE is likely to be 9 months. We know that there is the possibility for regulations to be made imposing a statutory cap on consultation. And we know that the employers can also run separate contractual probationary periods of any length they choose. So that's marvellous. That's what we know. But unfortunately, there is far more that we just don't know. It is completely unclear how that IPE is going to operate in practice. And although the government refers to a light touch regime with fair, transparent rules and processes, the substance of what that all looks like is going to be left to regulations. It's not clear at all how the test for unfair dismissal during the IPE is going to be different to the standard unfair dismissal test in section 98(4). And if there is going to be a lower test for unfair dismissal, well, where does that threshold sit to avoid the rights being so diminished that it's pointless? And what do we do about cases for a dismissal during the IPE, which are particularly serious with particularly serious consequences? So, for example, one wishes to dismiss somebody for serious misconduct and there are potentially career-ending consequences. Should this lighter touch regime that the government talks about apply to those cases, or should there be something more stringent and onerous required? As Tarun mentioned, in the next steps to make work pay, the government suggests this less onerous approach may involve requiring the employer to hold a meeting at which the employee is accompanied to explain the concerns. Well, as we saw, that was hellish when there were these mandatory statutory dismissal and disciplinary procedures, which formulated and escalated disputes rather than resolving them. And of course, it's not beyond the realms of possibility in the hypothetical world that we all live in that an employee, sensing the way the wind blows, finds themselves suddenly unwell and unable to attend a meeting and signed off sick until miraculously the IPE has come to an end. And of course, it's right that to be meaningful, there have to be procedural safeguards, such as a proper investigation. Are we looking, therefore, for a misconduct case, for example, at the sort of British Home Stores and Birchall type procedural safeguards, or will a different approach apply? Now, we just don't know. And the obvious practical effects to those changes are that the process of simply dismissing underperforming employees during the initial stages of their employment are going to be significantly more complicated, time-consuming and costly. And as Robert Peston and Tarun noted, this could have a chilling effect on social mobility. And also small and medium-sized employers are going to find it particularly costly and onerous to introduce processes for managing performance and misconduct during the IPE. And arguably, it may make employers less likely to hire rather than more. And to answer your question, John, I think it is inevitable that there is going to be a substantial increase in tribunal claims. And it's difficult to see how the creaking tribunal system is going to cope with that, particularly if there aren't changes to the ability to root out unmeritorious cases or to improve the circumstances in which costs application may have been made. There's also the question of how on earth these new day one rights apply to short-term contracts. I'm going to ignore Nick Siddall constantly putting his phone onto my nose, but not go into the detail of what those changes are, so that it's not clear whether there is going to be an IPE following the end of each conclusion of a short-term termination of a short-term contract, or only if there is non-renewal. Just dealing very briefly with the right to flexible working. The one big change in relation to that is that under the proposals, if an employer is going to refuse the right to for a flexible working request, that has to be a reasonable refusal. And again, it's completely unclear what that actually means, whether that is going to mean that employers have to make a decision that is within a range of reasonable responses, or whether their decision to refuse a request for one of the specified grounds is objectively reasonable in a sort of akin to a discrimination objective justification test. And in terms of the provision of the notice to an employer of why a request has been refused, again, it's not clear at present whether an employer is going to have to do more than simply summarize why the request is being refused, or set out every line of defense that it's likely to follow or want to stick with if there's going to be a tribunal challenge, which again may lead to further increased cost and hassle, because do you get the lawyers involved at that point to draft a very detailed notice, or run the risk that you get to a tribunal and they say, well, that's not what you said at the time. And just finally, in relation to the care proposals, and I should actually say in relation to flexible working, it's one of the few things in the Act which doesn't require further regulations to be made, which means that once the bill gets royal assent, it's like these changes are likely to come in very quickly. Just in relation to the to social care, there are currently no pre-existing law on sectoral agreements in the adult social care sector. The proposal is that the Secretary of State will have the power to establish an adult social care negotiating body, which will have the authority to negotiate and ultimately impose sector-wide agreements in respect of workers' minimum remuneration and terms and conditions of employment in the sector. Now, that's potentially an extremely significant proposal, and marks potentially a major shift in the UK's approach to industrial relations. Now, the government is clearly taking a very cautious and incremental approach to it at present, and there needs to be further regulations, and the government has expressly said that it will develop the sectoral agreement process in close collaboration with the sector, and it will need to be carefully planned. Hurrah, that's useful. So it could be one of the slowest changes envisaged by the bill to take effect. It also appears that those sectoral agreements negotiated by the ASC, a negotiating body, will then be enforced by the government's proposed new single labour law enforcement body, the Fair Work Agency. And it remains to be seen at present how large and well-funded that is going to be. So we can see that there's a whole host of areas of uncertainty, and it's a long road that lies ahead. Possibly the only certainty is that it will create enormous anxiety going forward for employers within the care sector even. So that's me.
Yeah, thank you very much. It's the best estimate is that 8.5 million workers will get rights that they don't currently have. And as far as I'm aware, at the moment, the government doesn't propose to give any more money to employment tribunals. So we're likely to have even more delays than we've got at the moment. But thank you very much, Carol. That was amazing to get through so much in 8 minutes. Thank you very much indeed. Now, I've got to turn respectful in my introduction of the next speaker, because he is our head of chambers, Gavin Mansfield, and he is and has been for many years one of the top employment lawyers. He has also sat in the Employment Appeal Tribunal, as well as being a Deputy High Court Judge. And he's going to talk about 0 hours. That's not related to the work as Deputy High Court Judge, because it is a very demanding role. As they say, don't look out of the window in the morning because you'll have nothing to do in the afternoon. And he's also going to talk. He's also going to talk about fire and rehire, all in 8 minutes. So take it away, Gavin.
All in 8 minutes. Thank you very much, John. I'll see how I get on.
No, we'll see how you get on.
0 hours. There's a suite of provisions in the bill that deal with precarious work. I'm only really going to talk about one of them, but the shape of it, there's guaranteed hours contracts, right to reasonable notices of shift changes or cancellations or changes in shift, and right to payment for short notice cancellations. All of this goes into the Employment Rights Act between Section 27BA and 27BU. Why they can't just add the sections on at the end and give them ordinary numbers, I don't know, but that's not the way that things are done. It's pretty dense material, and I just want to make a few observations about the guaranteed hours offer provisions, which I think illustrate that, partly because they're the centrepiece of the section, and also because they illustrate some of the challenges of the approach that the government has taken. It seems to be the central idea is pretty straightforward. If you work under a 0 hours contract or a contract for low hours, but if in fact you regularly work more than the minimum hours provided for by your contract, then your employer is obliged to offer you a contract that reflects the hours that you've actually been working. I mean, that sounds straightforward, doesn't it? But it takes 14 pages and 9 sections to get through that. I think I've got the gist of it right. But despite the 14 pages of sections defining that answer, you'll all be thinking, well, that sounds so simple, but what do you mean by 0 hours contract or low hours contract? Or what do you mean by regularly work? And the answer to that is, I don't really know. Not because I don't understand the sections, but because the sections are riddled with key concepts that are left to be defined by regulations that are to come as a result of consultation. And I think that tells us two things. First of all, we aren't going to see these provisions coming into effect anytime soon. And second, it's difficult to know what the impact of them is going to be until there's been consultation and some further regulations. I mean, I can see the position that the government was in. They committed to a bill in 100 days. But one of the reasons the drafting is so cumbersome is because they set themselves that time limit. It's the old adage, isn't it? They haven't had time to write a short speech. It's much easier to write a long and more complicated one. So I just want to make some points about some key concepts. Qualifying worker is a central concept. 3 points. First of all, we're talking about workers. So the government has also indicated that in due course it's going to consult on moving to a simplification of status to move those workers to be employees. I suspect across a whole bunch of these rights we're going to see some battles to come on worker status intensifying, because these are going to be remain key threshold concepts. Second, the provisions as they stand don't apply to agency workers. There's a power in the bill to extend to agency workers, and there's a current consultation ongoing as to if or how these provisions should be extended to agency workers. Massive battle to be had on this relation to that, I think. Third, within the scheme as it's currently contemplated, qualifying worker has 2 key concepts. One is contractual hours, 0 minimum contract hours, that's easy to understand, but also contracts where the minimum hours that can be provided are low. Low is at the minute an undefined term. It will be defined in due course. That's going to make a massive difference. If it's defined as 2 or 3 hours a week, then effectively that's a 0 hours contract to all intents and purposes. But interestingly, in the Bill Committee, one of the Conservative members asked the minister what low meant. They have a wild time on these committees. He didn't answer that question. He said it was going to be a matter of consultation, but he said this is just in Matters back in December, in relation to the retail sector. He said people who work in the retail sector can be on guaranteed hours of 16 hours a week, but still face insecurity. So I think that may be a nudge in the direction of when the government says low, it means something that's effectively a quite substantial part-time work. And if we're moving that far for low hours, then these provisions will have a much wider impact than the 0 hours population. The second key parameter is the reference period over which hours are worked. And that also is as yet undefined, although the government has indicated that it thinks that the reference period should be 12 weeks, although it's going to consult about it. Various CBI, the CIPD, various industry bodies have said that's too short. 26 weeks would be a better reference period. So this is the time period that you look at the actual hours worked by the employee. And if it's more than their contract provides for, the employer has to offer a contract which reflects the actual hours worked in the reference period. And that's going to be problematic for sectors that have seasonal work. If you've got a contract, you've got to oblige to offer a contract going forward that's fixed by hours that are worked in a different season. It's going to be problematic in sectors that have much more irregular work patterns. There's a battleground, I think, to be had in the consultation about how long the reference period is. There's also a battleground about what reflects mean. The contract that the employer has to offer has to reflect the reference period. And there's a provision that says that regulations will define what that means. If it means an average over the period, that's one thing. I suspect it's going to mean something more complicated to weed out atypical periods of work within that reference period. And there's also provision for regulations to provide for absences of one sort or another, sickness or for other reason if the reference period the person's not working. So there's everything to play for. I think what it's going to mean, come what may, is that we're going to see a huge amount of paperwork and administration simply keeping on top of who's been working what hours in a reference period on an ongoing cyclical basis and repeated changes of contracts. So that's a lot of transaction cost involved in that. Time says I'm going to move on to fire and rehire. I'm going to deal with that very quickly. This is another provision that is good to go, doesn't require consultation and further regulations to come into effect. Government said it was going to ban fire and rehire. Has it done so with the new provisions that go into section 104I? Answer to that, no. It adds in new grounds of automatically unfair dismissal. One to cover the fire and rehire situation, as we classically know it, and one to cover the fire and hire somebody else situation. So where you fire workers because they won't accept a contractual change with the intention of hiring some new workers instead to do their roles. Both of those automatically unfair dismissal unless a defence can be made out. And that is, the defence says that it's not an automatic dismissal if the employer can show that the reason for the variation was to eliminate, prevent, or significantly reduce, sorry, I'm going to read all of this out, or mitigate the effect of any financial difficulties which at the time of the dismissal were affecting or were likely in the immediate future to affect, 1, the employer's ability to carry on the business as a going concern, or 2, otherwise carry on the activities constituting the business, and in all the circumstances, the employer could not reasonably have avoided the need to make the variation. Bit of a mouthful, 3 points. 1, are the permissible reasons in that defence wide enough? Some commentators are saying it's too narrow. It's only about financial difficulties. Why not technical or organisational difficulties that allow for where employers need to make changes which are not related to financial difficulties? 2, will tribunals be equipped to make the sort of economic and financial decisions that this section provides for? We know for years in redundancy cases and in some other substantial reason cases, tribunals have been very shy of effectively seen to be making management decisions for businesses, but this section will require them to do so, it seems to me. And third, will we see, it seems to me we're likely to see, an increase in the use of unilateral variation clauses in contracts to avoid getting into this situation in the first place? And there are a lot of trade unions have been calling for amendments to the bill to close that loophole to forbid those sorts of unilateral variations. But watch this space as to see what happens there. That's my 8 minutes. And I'm
Thank
done.
you very much indeed. And last but not least, fellow Northerner, Nick Siddall, who practices in both the High Court and the tribunals. Take it away, Nick. You're talking about statutory duty in relation to sexual harassment.
I am indeed. Thank you, John. Marvellously, my laptop has just chosen to crash. So while I'm frantically waiting for it to reboot, I'll engage in what's classically described as filling on the radio. Oh, thank God it's back. It's fair to say that harassment seems to be a hot topic at the moment, because what we have is a situation where the government, or the last government, recently introduced new provisions dealing with the liability or the obligation to prevent sexual harassment. And we then see matters going a further stage. Now, it's not for me to talk about the rights or wrongs of the proposals. It does seem to me that, as compared with some of the other provisions, there is arguably a question whether the moral case is made out as to whether the obligation or the forgive me, I'm just waiting for this to boot up and it's not, as you've probably gathered, whether the moral case is made out that liability should be imposed on an employer for the actions of a third party. But anyway, brief reminder for all of you. Obviously, starting point is harassment is prohibited in circumstances where, on grounds of a protected characteristic, hostile environment is created which is related to a protected characteristic. There is a statutory defence if the employer is able to show it took all reasonable steps to prevent the harassment. That's the basic position. We then have the duty that has recently been introduced to prevent sexual harassment. So the obligation relates only to sexual harassment. And here the test is you can avoid liability if you took reasonable steps. Now, that provision is being worked through at the moment. There's no decisions on it at all. But what we do know is that the government or the HRC guidance suggests that it captures third-party liability. So now we arrive at the provisions of the Employment Bill. And effectively, in the context of harassment, it's making two broad proposals. The first is reintroducing liability for third-party harassment. And you'll recall there were third-party harassment provisions in the Equality Act as originally formulated. The big difference between the previous position and now is that previously it was the case that you required a course of conduct. You required two occasions. The provision now says liability for third-party harassment without a course of conduct. So what it is expressly seeking to do is introduce an anticipatory duty, and it's in those circumstances different from other areas, for example, the Protection from Harassment Act, where there's a requirement for a course of conduct. We then have the recognition that because it's an anticipatory duty, what is the employer supposed to do? Now, the employer is entitled to avoid liability if it can show it took all reasonable steps to prevent the third-party harassment. So what we have is all reasonable steps defence for liability at the moment under the general harassment provisions. In the context of prevention of sexual harassment, we have a duty which is if you took reasonable steps, you won't be liable for harass or in terms of your breach of your duty to prevent sexual harassment. And the fact that we see the reintroduction of the all reasonable steps defence obviously suggests that the intention of the government is to increase the protection which applied as regards the duty to prevent sexual harassment. And the wording is the same as the statutory defence which currently applies to discrimination claims. But obviously, those have got, I'd suggest, to mean different things, because obviously the extent to which an employer is able to take all reasonable steps in terms of its own employees is going to be very different from the extent to which it can take all reasonable steps in terms of third parties. So what does that mean? Well, picking up on a theme that Gavin raised, the indication is that there are going to be regulations which indicate what are going to be examples of reasonable steps. Now, the first difficulty that opens up, of course, is that a tribunal might say, well, it's all very well what these regulations say, depending on what they do in fact say, but there are other steps that you should have taken. We also have seen that there is the problem that this liability will apply across all forms of harassment. It's not limited to sexual harassment. And you may have recently seen that the EHRC wrote to the government raising a query and a concern about what it described as the overheard conversation liability. So in fields, for example, hospitality striking one as an obvious example, that if an individual overhears a conversation, there's the potential for liability in those circumstances. And the EHRC also raised the concern about what if the view that's being expressed is said to be the discussion of a protected belief, for example. And so the current EHRC proposal is that the government should consult on the extent to which the provisions as drafted might impact or might be affected by Article 8 and Article 10 considerations. Now, the duty is preventative. So the point that arises at the moment is the only real guidance which exists is the guidance which has been issued by the EHRC as regards the duty to prevent sexual harassment, not all harassment, and it suggests a number of preventative steps that can be taken. Employers really, it seems to me, need to be looking at that now, because even though there is indicated to be a relatively long consultation period and implementation period for this new duty, it's likely that on day one, if claims are issued, a tribunal is going to look backwards about what the employer was doing at the moment. So the best guidance appears to be look at the current EHRC guidance on sexual harassment and try and introduce that more widely. So that's the principal change in harassment. The second change in harassment is that there are provisions in the bill indicating that the reporting of harassment will be viewed as a protected disclosure. Now, that seems to me to be a change which isn't going to have an enormous impact, because already if you complain of harassment, you're going to be protected against victimisation. The only real change that seems to introduce is the possibility of an application for interim relief, if it is indeed a whistleblowing disclosure. But as my computer didn't boot up for the entirety of that talk, I'll hope you forgive me if it wasn't as polished as some of those of my colleagues. Thank you very much.